If you're worried about custody, placement, and how the court decides what's best for your child, then this video is for you. Today, we're breaking down Wisconsin's best interests of the child standard, what it means, what judges look for, and how you can put yourself in the best position to have a meaningful role in your child's life. First off, what I want to talk about is the best interests of the child standard. And that's the legal framework, and in Wisconsin, the court's top priority is the best interest of the child, not the parents' preferences or what their choices are, what's convenient to them, not what's fair between the parents, but what's truly best for the child. The Wisconsin statute that is relevant is 767.41 on custody and placement factors. The court evaluates a list of factors to determine this. Let's go through them one by one, and I'll give you a moment to think about how each one applies to your case. For bonus footage, stick around to the end, I'll do a deep dive. So number one is the wishes of the child, considering the child's age and maturity. Number two is the wishes of the parents. Number three is the interaction and interrelationship of the child with their parents, siblings, and anyone else in the house who may significantly affect the child's best interest. Number four is the quality of time that each parent has spent with the child in the past and any necessary changes to custodial roles and the effect of those changes on the child. Then we have the child's adjustment to home, school, religion, and community. Another factor is the age of the child and the developmental and educational needs at various ages. Another factor is the mental and physical health of the parents and the children. Another factor is the need for regular and meaningful time with both parents and the ability of the parents to provide it. Another factor is the cooperation and communication between the parents and whether one is likely to unreasonably interfere with the child's relationship with the other parent. Another factor is evidence of abuse or neglect by either parent. And then we have evidence of alcohol or drug abuse. Another factor is criminal records of either parent. And then the last factor is any other factor that the court considers relevant to the child's best interest, and that's unique to your case. So if you're a dad seeking placement or custody, the best thing for you to do is not just say it, but to show it. You need to show you're actively involved in your child's life. In this next part, I want to talk about overcoming bias and how to prove your case. And the tough thing that comes up is that sometimes dads worry that courts favor mothers in custody cases. And Wisconsin law is gender neutral, and biases can still exist, however. The best way to fight that is to come prepared. So here are four things that judges want to see. Number one is consistent involvement. Are you attending school events, doctor appointments, going to kids' activities? Keep a parenting journal of what you're doing. Number two, a stable home environment. To have equal placement, show that your home is set up for the child. There's a bedroom that's close to the school. Number three is, are you demonstrating good parenting behavior? Are you not bad-mouthing the other parent? Number four is, judges really like to see employment and financial stability. So while child support and placement are separate issues, showing that you can provide financially is always a plus. Now, avoiding common mistakes, and that is something you really need to do. So let's talk about these mistakes that can hurt your case. Number one is not following temporary orders. If there's a temporary custody order or placement order that's in place, follow it to the T. Judges want to see that you respect court rulings. Number two, don't ignore communication records. Courts love documentation. Keep texts, emails, notes about co-parenting interactions, especially if the other parent is making false claims so you can disprove the claim. Number three is missing court deadlines. Don't miss court. File your paperwork. Show up when you're told to come. Go to mediation. Don't miss any of that. And number four is bad social media behavior. Avoid posting online about your case, dragging the other parent into there, or talking about your case. It's just not helpful. I want to talk to you about some legal strategies, and this will improve your chances of a fair outcome. Number one is get a guardian ad litem involved in the case. Request this of the court. Guardian ad litem is there to serve the best interests of the child, and work cooperatively with that guardian ad litem. You also want to consider mediation. Judges do like parents to work it out themselves, so be open-minded and consider going to mediation. It can lead to better agreements versus a court battle. If you're seeking to increase your placement time, file early. If you want to have equal time, request it from the get-go and tell the judge exactly what you want. And finally, of course, consult with and please hire an attorney. Family law is complicated, and having a skilled attorney can only help you in your case and make a huge difference for you. So the bottom line in Wisconsin is that courts want to see that you're a loving, responsible, and engaged father. And as long as you demonstrate that, you will do well. Understand that the best interest standard is important. Avoid the common mistakes that we discussed here and come prepared for your matter. Now, if you have questions or you need help with your case, please reach out to us at HKK Law Offices. We're here to help. We specialize in family law. Now, I did promise some bonus content for you, so if at this point you're departing, thanks for watching, but I'll give you some bonus information on the factors. First one we talked about is the wishes of the child, considering the child's age and maturity. What you need to know, though, is that courts do not want children to come into the courtroom. So your child is not going to testify or write letters to the judge. Work with your attorney to figure out how the child's wishes become part of the record, but don't expect that your child's going to be sitting in the courtroom. Number two is the wishes of the parents, and that's usually communicated by what's called a proposed parenting plan. We've talked about that before in videos. Please watch them if you haven't already. Write down what you want, file that with the court ahead of time for your hearing so the court knows. The third is this interaction and interrelationship of the child with parents, siblings, and other people who could affect the child's best interests. So what you want to think about are, who lives in my household? Do you have a significant other? Are there grandparents involved? And how all those people could be a positive or negative to your case. To go to an extreme level, if you're living with somebody who's like a drug abuser, that could be problematic for you and your child, of course. So that's an extreme one, but think of these things. The amount and quality of time that each parent has spent with the child in the past, that talks about continuity. And I just want you to know, if you had a role that you worked and the other parent stayed home, what's important is that when you go to court, you outline a plan for how that is going to change. So this factor does consider the reasonable lifestyle changes that you're going to make, such as, I've adjusted my work schedule so now I can be there for my child in the morning to wake him or her up, take them to school, feed them, and so on and so forth. I wanted to talk about the child's adjustment to homeschool and community. So a lot of kids are already adjusted to the homes they live in, and what you want is the child to have options in the place that you live. If it's a new community, get them involved in the community. If it's your home, make it comfortable for them. We want kids to enjoy the places where they live and spend their time. The age of the child and their developmental needs, you have to think about that. Are we talking about an infant? Are we talking about a child who's 6 months old to 4 years old? Are we talking about school age? Are we talking about teenagers? Every child needs something different, and that's important to understand that. The mental and physical health of the child and the parents, that is a factor. The fact that you have a physical disability or a mental health disorder does not necessarily mean you are a good or bad parent. It's how those symptoms play out and affect the child. So you want to think about those things a little bit deeper and make sure that those stories are being told in your court case.